Good morning, everybody. My name's Rohish Gupta. I'm Policy Manager at the Victoria Tourism Industry Council, and on behalf of VTIC, I'd like to welcome everybody to today's webinar, 19th September at 10:30 in the morning. The topic for today's webinar is going to be, does your business market in the European Union? And with that, an update on recently introduced privacy rules. I'd first of all also like to acknowledge Visit Victoria for their joint initiative and cooperation in bringing this webinar to you. It's really great that Visit Victoria have worked with VTIC around bringing this very important and relevant topic to our attention on the back of strong feedback from the industry. So very grateful that that's happened, and we're very thankful to them. So additional to that, also like to thank Webfirm, who is our web partner, and that's who we're organising this webinar and bringing it through to you today. I'd also like to give a couple of housekeeping reminders. The webinar will be posted on YouTube after its completion. So for those that might need to leave early, or really encourage you to also share it amongst your business community as well, and really encourage you to go have a look, or if anybody you feel that might be able to gain some insight through it, for them to go have a look at it later on as well. Also really encourage everybody to ask a lot of questions, so please type through all of your questions and send them through as much as you can. We want to build up a really strong bank of questions. We've got very experienced, well-credentialed facilitators with us today that are able to give us very good insights around how important this topic is, both from a legal and marketing perspective. So the more questions you have, the better. And once both of our presenters have gone through an introduction about sort of individual aspects of the new rules, we will then go through a conversation in which we will ask all of your questions. So let's get cracking. But first of all, I'd like to introduce our two presenters that we've got helping us today. So first of all, introducing James Stevens, Principal Solicitor at the Victorian Government Solicitor's Office. And we've also got Gail Weil, Deputy Chief Executive Officer at Clemenger BBDO. So first of all, we will hear from James, and he will give us an overview around what the GDPR is and some sort of key elements that are really important for all of you to know. So handing over to James now. Thank you.
Thank you, Rohit. Hello, everyone. So the GDPR, what does that mean? It's the General Data Protection Regulation. So basically, it is the European Union's newest privacy laws. So think of it just as Australian privacy law, except it's been passed by the European Parliament. And on the slide, you'll be able to see the quote which says it will fundamentally reshape the way data is handled across every sector. Now, let's unpack that a little bit. What does it do? So if you're processing other people's data, and those people are in the European Union, this will apply to you, because the trigger for its applying to you is not based on where you are, but the effect that you might have within the European Union. And that's possibly the most major or radical of the changes relative to the EU privacy laws to date. So what are the purposes of this? It's really about protecting the rights of natural persons who are in the EU, their rights to privacy, but it's also to encourage the free flow of information. And I think that even though the European Union, at least geographically, is a long way away, these new rules are intended to reflect the fact that more and more we are having marketing and data collection based on basically new technologies such as the internet. So if you're an Australian business with an establishment in the EU, you'd obviously be covered, but at the same time, if you're offering goods and services to people in the EU, or you're monitoring the behaviour of people in the EU, and that's could be as much as just compiling customer lists, then you may need to comply with it. And the new rules switched on 25 May of this year. So there's a lot of commonality between the GDPR and Australian privacy law. So those features include you need to design privacy into your business models, and you need to have transparent information handling practices. So some of these requirements aren't necessarily going to be new to you. There are also the concepts of consent and open access, which are already provided for under Australian and Victorian laws. So it might be that you're actually already a long way to complying with the GDPR as it already is. But you should actually be thinking about what you need to do in terms of your information handling practices, your governance structures, and also whether or not you need to seek advice as to whether or not you need to do anything differently if you are, in fact, collecting information about people who are in the European Union. And one of the things that it's not just a legalistic approach that you need to take here, you also need to think about whether or not you've got the software you're using or how you're keeping information is actually got the capability of enabling you to comply. So, these are some examples of who the EU GDPR actually applies to. Now, if you're a business and you're a data processor of information or a controller, we'll come back to those terms, you will be subject to the law. So, a data processor, think of that as being someone who is doing the actual processing of the information, and a controller is someone who actually decides how the information is processed. And so what the GDPR brings in is there's some principles as to whether or not you are actually processing the information lawfully. There's rights given to the individuals the information relates to. And let's have a look at some of those examples. If you're an Australian business with an office in the EU, it'll apply to you. If you're an Australian business whose website enables EU customers to order goods and services in the European language, or enables payment in the euro, if you're an Australian business whose website mentions customers or users in the EU, or you're an Australian business that tracks individuals in the EU on the internet and uses that as part of profiling individuals to analyse or predict their preferences and behaviours. And I think in the context of the audience we're speaking with today, that's going to be about marketing. So we've touched on who a controller is and who a processor is. One of the new steps, which is, and this is one of the differences with Australian law, is that the requirements of people who are doing the processing of the information are almost as much on the hook as the person who's deciding how much data processing is going on and how it's done. So think of, like for instance, if you have software or even a contractor who's doing your marketing services for you, they would be your processor and you would be the controller as the purchaser of those services. But at the same time, you've both got responsibilities under the GDPR. Now, a data controller has to ensure that the processes that personal information is being processed for is lawful, so that would be your responsibility. And you've got to show that you've got a legitimate interest in order to do it. Now, legitimate interest, if anyone happens to have a copy of these rules in front of them, have a look at paragraph 47. It has some discussion about what you can be included there. But what it includes is if you've got a client relationship with the person already, if you're looking at direct marketing, you can also be processing data just for your internal admin purposes, but you might also be engaged in research and statistical analysis of people who are in the EU for the purposes of your own marketing, in which case there are also rules that apply to you under the GDPR. So consent is one of the hot topics where the GDPR contains quite a higher degree of precision than the actual Australian laws do. These are kinds of matters which are often covered under guidance from a regulator in Australian law, so you're not necessarily having to comply with it. Under Australian privacy law, you can have consent is implied. I wouldn't say that the GDPR rules that out, but it's got a very specific definition of how it must be given freely. It's got to be specific, and it has to be informed and unambiguous indication of what the subject actually wants to opt in for. Consent, if it's not freely given and the individual doesn't actually have a free choice, then you can't really count that as the individual as having consented. So if you're signing someone up to something and they've got no option but to click yes, then, well, consent isn't really a genuine basis in that case. One of the other hot topics that we've received quite a few questions about where I work is the right to be forgotten, and I think that's caused a bit of a stir because it really relates to people being able to request that they be erased from your data sets. Now, that's an important right to establish, but at the same time, we need to remember that it's not an absolute right. If you've no longer got a purpose for the information, that's a good reason to let it go. But at the same time, you might still have other lawful bases for keeping the information. You might be legally obliged to do so under Australian law, for example. And the other points which are worth noting is that by and large, the principles and the rights that are provided for under the GDPR are effectively, they've got a high degree of correlation with what's already provided for under Australian law. It just elevates some of those aspects to the position where someone is able to actually take action to make sure that their rights are protected. At the moment under Australian law, it's not as though you can't do these things, but at the same time, the individual mightn't be on as strong a footing as they would be under the GDPR. And so that's all from me for the moment.
Lovely. Thank you very much for that, James. A really succinct but also detailed overview around what are, I guess, the key legal principles that Australian businesses and the types of Australian businesses need to watch out for. So that's really great, and we'll come back with you when we have a conversation and go through a couple of questions. So as I mentioned earlier, now I'd like to introduce Gail Weil, Deputy CEO of Clemenger BBDO, to go through an overview of some of the marketing and some of the marketing types of conduct that may fall within the scope of the GDPR. Over to you, Gail.
Thank you. I'm not a legal expert, so I'm not going to be giving anything as specific as James, but really, as James was saying, all individuals and companies who collect and or process data from European users must comply regardless of their country of origin. So you can imagine the scale of the undertaking of GDPR. And I think from a marketing perspective, whilst this was seen as a huge undertaking requiring different roles, it was also a brilliant opportunity for many businesses to actually review how they interacted with consumers and to ensure that they took best practice to build that trust and confidence, which is as relevant for Australian businesses as well. So if we look at some of the impacts for marketing, especially email, and that's probably one of the prominent elements. Sorry, if we just move on a slide. Then really, as James was saying, as an email marketer, what was really important is that people have this choice that when they're giving their data, it is freely given, specific, informed, and unambiguous. And we'll come to some examples of that as well. But really, in conjunction with that, businesses also have a clear responsibility to ensure that people who provide data have the right of access, the right of information, the right to rectify, and the right of portability. And it's really some of these which led to the greatest changes in the way that marketers were behaving. So I'll just talk through some of the practices that they adopted, such as proof of consent storing systems, opt-in to permission rules, and also methods that were put in place mainly through preference centres to enable consumers to request removal, to enable them to actually rectify their information, and also to bring about portability. So proof of consent, and that should, apologies, say proof of consent storing. So organisations need to keep a record now of how they obtain that express consent, and express being the kind of chosen word there. It can't be implied. So we need to look at making sure that storage is there for the data subject themselves, so that there is uniformity and a lot less ambiguity in who the data subject is, when the consent was obtained, whether that's through a date and timestamp, and also the specific purpose for which the consent was given. And that is really important. We'll come through to some examples of that. No longer, from a GDPR perspective, can you just have a one catch-all opt-in and expect that you can email out any type of message with that. You have to be very specific in the type of messaging people are consenting into, and to give them the option to unsubscribe from certain types of messaging as well. Keeping a record of the IP address, location, and time of that submission is deemed as insufficient without a screen capture of the form itself as well. And that's just to be beholden that there was enough specificity into what people were opting in for. So what a lot of businesses within the EU are actually doing is keeping a copy of the confirmation email, or keeping some record that that was actually interacted with. I think the biggest learning from particularly the UK and many of the European countries is that GDPR applied to their historic data as well as data coming before. So what we saw from some UK examples in the run-up, so in the late 2017, is that many businesses tried to get on the front foot. So there were some examples where actually companies like Flybe, which is an airline there, Honda, and a local supermarket there, Coles equivalent Morrison's, were actually fined significant amounts of money because under the PECR, which was the predecessor to the GDPR, they had gone out and communicated to their database to try and seek consent and opt-ins ahead of the game. However, those people hadn't given their consent. So someone like Flybe was fined £70,000 for sending more than 3.3 million emails to consumers who had booked flights but not opted into marketing emails asking them to update their data. It's actually led to one big case where a pub chain called Wetherspoons actually deleted their entire customer database of nearly 1 million customers because they had no formal consent records to show that people had opted in. So rather than carry the data and be held at possible liability for holding things that weren't applicable or compliant to the GDPR, they actually wiped the whole database and decided that they would stop email marketing. We just move forward. One of the most common things that you would have seen as Australians, even, we got a barrage of emails around re-permissioning. So this was one of my favourite tweets from around that time from Jane Merrick. GDPR emails are by the day sounding more and more like the world's going to end. And there are two subject line examples ahead of you there. So Waterstones, it's goodbye from us, the final Waterstones Weekly, and National Trust, time is running out, will you stay in touch? And I think, as you'll see, it was really important for the businesses. What they had to actually do was to be very clear that if people weren't opting in, they would no longer hear from them, that it was a deletion moment. So if we just look at some of the ways that repositioning emails were actually structured, they were different purposes. So from the first example you've got there, Thrive, it was a very straightforward example. And the way that they talked about it was, yes, please keep me subscribed, or no, unsubscribe me. And that was a B2B example. So in its very nature, it was very functional. You'll see next to it there a game example. So they're a bit like EB Games. They sell computer games. They went a step further because they obviously had people opted into far more variations of emails. So by clicking the resubscribe now button, what you actually got taken through to was a page on their website where you could opt into different types of emails. So whether it was their loyalty program emails, whether it was offers or new releases emails, it gave you a lot more capacity. The third example there is from a B2B company who actually send out emails. And they've got a lot more copy around what they're trying to opt you into. So you can see there, they're saying, is it the monthly newsletter? Is it their live conference news? Or is it in-depth research results? Again, if you click yes, send me emails, you then get the option to select which of those types of emails you want to opt into. Giving one general consent would not have enabled them to send all of those different types. And again, they're really clear there that you can unsubscribe, but if you do, you would no longer hear from them at all. So it is a total shutdown. And then MailChimp, that final example, MailChimp, many of you may work with or you'll understand. It was also really important for Google and the likes of MailChimp, who are enabling a lot of that data collection, to not just make sure that their customers were opted in to hear from them, but also that their customers were compliant in things like terms and conditions. So what you'll see here from MailChimp is them going out to customers, asking them to confirm and to accept the new terms that will be there around data collection and that behavior. So the other big change that happened in opt-ins is that, as we talked about, consent cannot be implied. You can't have passive opt-ins. And so what was instigated by a number of organizations was a double opt-in. So as you can see there from the Skyscanner example, if I'm signing up for a price alert, I can put in my email address. You can see beneath it a tick box where I can opt in for other types of email communications, be that news or travel tips or deals, and I can create my alert. Then I will get an email confirming, or they sometimes do it in a pop-up window, but I need to then second opt in to confirm that, and I will not be communicated about the price alerts until I have taken that action. So that is again enabling them to store that they have got that firm consent, not an implied consent. And just some examples here in permission rules. So as James mentioned, there was a lot here around language and also making sure that it wasn't implied, that there was a clear choice for people around opting in. So on this next example, what you'll see is a written piece there, so some language that was used. And again, this is not saying this is the only way to say it or the preferred way to say it. It is just for example purposes. Just having some copy there that you agree that Gales Wines may collect, use and disclose your personal data which you have provided in this form for providing marketing material that you have agreed to receive. In accordance with our data protection policy, please tick the relevant boxes below if you agree to receive, and each different type of communication would be broken out. And you can just see there as a visual example next to it what is seen as compliant and non-compliant from a GDPR perspective. So in Australia, we see far greater occurrence of implied consent, which is the first example there, where to be able to action, I just click start free trial, and underneath it you can say that it is being implied that I am therefore taking forward and opting into marketing communications. As you see in the GDPR compliant version, I have two choices there. I can opt into communications which are relevant to my free trial, but I also have the ability to opt into marketing communications around offers and events. And so I would need to select those to be compliant. So if I just opt into the trial, I would not be able to be targeted for other marketing communications. Outside of email marketing, user profiling was also came under scrutiny as part of GDPR. And this isn't particularly relevant, as in today's automated marketing, we look to use more cookies and we look to use more online behavior in which to target messaging and to reconnect with users. So whether that's, collecting my behavior and searching car reviews on Google so that people, car manufacturers can talk to me, or whether that's simple as flight kind of offers. Collecting the browsing history, education, information, and buying habits is allowed, but it must comply to the transparency laws, and it must also be kept to all of the consent details as well. So it needs to be clear in your terms and any cookie opt-ins that you have on your site. And upon any data subject's request to halt PROSUP filing, that processing must cease to exist, and we must show, or the data controller must show that that has been complied to and the user's best interests have been taken. And just a reminder there that obviously no profiling can be used on minors. And just finally, looking at how we tackle the ability for updating and for portability of data. So most businesses sought customer preference centers as the most transparent and user-friendly way to enable people to manage their preferences. And it is ultimately about transparency, and this was a great way to enable that. So it is about taking forward that it's not just how we gain the consent, it's actually the guidelines for how businesses maintain it. So transparent opt-ins and opt-outs that the user can access at any moment. On top of that, what a number of businesses, like the first example you see there on your left, do is they enable people to opt out for periods of time. So rather than hard unsubscribe, which means you're gone forever, I might decide if I am opting into travel messages, for example, that I just want to hold out for a period of time because I'm not looking to travel for the next 3 to 6 months. So I can actually put on hold messages that I've got and go back in and upgrade them. I can also, on the first example, decide the level of information I get. So if I just want to get summaries versus if I want to get the full information. You'll also see on the side there that they have different sections as well, giving people greater control of their data. So the top button there is on subscription, so I can opt in and out at any time, but you'll see below that it also has my reminders and my favorites. Again, this is all about the behavior of tracking people. So if I have on Airbnb put a load of places in my favorites or my wish list, I need to be able to remove that data at any point as well, so it is not held if I do not want it to be held. From looking then at just different ways and ease of ways for people to be able to subscribe or unsubscribe at any point. And as you can see, to aid with the transparency, what most businesses did is make a very visual and a very easy way for people to maintain their decision making. So in summary, they were just some ways that marketing companies have really looked at how they contain consent and how they manage that moving forward.
Lovely. Thank you very much for that, Gail. Some very practical examples and also some examples of the kinds of pitfalls that businesses should watch out for. So yeah, really great presentation there, and also thank you to yourself, James, as well. So look, we've got some really great questions coming in thick and fast. So please, I encourage everybody, if there are questions either for James or for Gail or for both, it'd be really great for us now to use the rest of the webinar to actively engage everybody and to make it a bit more conversational. So please have all of your questions coming through. Got a really great question to hit things off from Rebecca. And this question is around Facebook advertising and using custom audiences, for example, matching your e-news subscribers within Facebook or matching website visitors to Facebook audiences using your website pixel. And the question is, what do tourism brands need to do to ensure they are not breaching the GDPR if advertising to potential customers in the EU? Do they have to get express permission to undertake this type of advertising and the ability to opt out? And how is best practice to do this? So over to both of our presenters, if you've got a view on that question.
Do you want to go first, or shall I?
You go first.
Yeah.
And, yeah.
Great.
Well, I think that you'll be able to. You'll have a presence in the EU where people will be able to access your website, or they'll be able to contact you by email. There's no threshold that you've got to meet before doing that, but once you're doing it, you just need to be sure that you're doing it in a way that is compliant with the GDPR rules. So if you're mailing to people, the preferable position would be to have their consent for that. But for example, if they're existing clients who you're providing a service to, that might be covered as a legitimate interest of yours already. So it depends a bit on whether or not your presence in the EU is completely new or not. Gail?
Yeah, my understanding on it is, and Google and Facebook have updated terms and conditions on all of their sites to apply to this. That given if you are taking the data or the behavior from the activity you're doing back out, then you do need to have in your terms an updated clause which states that you will be using that information based on cookies or however you're doing it to advertise. Also in your consent, when people are opting in, if you're using your email database to connect to Facebook, somewhere in your email collection terms and conditions, you would be stating that the consent is also allowing for advertising messaging.
Fantastic. Thank you both for that. So, Gail, just you mentioned cookies in your answer there. So I think that's a really good segue into our next question from Sandro, and that's around, if I do not actively place cookies or require data from cookies, will I still need to place a notice on the website about cookies on behalf of a controller?
The short answer would be yes, because assuming that the cookie actually will in some way relate to the information of a natural person. So keep in mind, though, that that's what the GDPR relates to, but there will be an incoming law from the EU that directly provides for cookies in addition to the GDPR. And so we just have to hang tight till that happens.
Okay. Yep. Good to know. Any further thoughts on?
I think there'll be lots and lots of kind of amendments to regulations. I think all consumers will have to get used to clicking I accept a lot as they visit different websites, I think.
Yeah. No. Fantastic. And no, definitely there's a lot to watch out for. So I think one other question, and this is obviously, you know, I guess a simple sort of blanket all type of question in a lot of ways, is should I just prevent European Union traffic, or is that something that is even an option for businesses, or is that not really sort of necessarily or the right way to go?
Oh, well, it's potentially a drastic business decision if you're relying on EU customers. But it would certainly take you outside the scope of the GDPR, at least for any new customer information. If you've got no presence in the EU, then you're outside the scope. But it's a business decision, really.
Yeah. So, no, and that makes sense.
I think yes. To James's point, it feels like you would be perhaps making a radical decision that might not suit you in the future. And I think as well, don't forget, it is about if at any time you want to go in, you'd be starting from scratch versus at least being compliant now and building, even if you're not using it at this moment.
Yeah. I think that's actually, I want to throw a quick comment in on the back of that, which is even if it doesn't apply to you directly, we've actually seen a lot of cases where people have been able to get increased market share by saying, oh, by the way, what we do is GDPR compliant.
Yeah.
And so even if it doesn't actually apply to you, it puts you in good stead with customers and business partners.
And I think whilst GDPR is relevant to Europe at the moment, Canada have gone through a similar legislation around data and privacy. We will see a lot more of this type of this scale of legislation happen across the globe. So you're kind of you're going to have to do it at some point as your business grows out of Australia.
And there is also the federal government here in Australia has committed and is developing currently consumer data protection rights, which I haven't had a chance to have a look at the draft legislation, but I wouldn't be surprised if it closely mirrors the GDPR in some respects.
Okay. So. Yep, and that was going to be a little bit of a question from me, just in terms of, you know, like there are some key differences between Australian privacy law and then the GDPR, you know, and I think that sort of helps answer it, that the Australian government has recognised that there are some shortfalls and gaps, and if they are catching up to that currently in draft legislation, then I think that's good comfort and good confidence for the local business community. So one further question that's come through from Karen, really important, is do the GDPR rules apply in the same way for business-to-business communications? Do we have a view on
My
that?
understanding is that it is yes, because it's any individual or company,
Yes.
and therefore it doesn't matter. So we saw it there with Thrive and Litmus.
Yep.
Two examples I had on recommissioning. They are B2B companies, not B2C companies. So yes.
Okay.
I'm yet to hear of a company that doesn't have a natural person involved in it. So yeah.
No. So I think
It will come though.
it might come.
Yeah.
Yes. No, I think and as you touched on earlier, James, the fact that there's the application to natural persons, it's pretty broad-reaching. So no, that's good. Question coming through from Fiona. So what happens, and I think this is an important question around this, is what happens if, let's say, a customer or someone signs up to e-news over the phone and that is not recorded? What are the ramifications of that, given that it's a telephone conversation as such?
So my understanding would be that therefore is not applying to GDPR, that the source of data is irrelevant. It is how you hold the data and getting that consent. So phone scripts and so forth have changed with European businesses, so that if I am being asked on a phone call, would you like to opt into, I am being given a list of what I'm opting into, then they would get the secondary email to self-opt in themselves. So they would be emailed out, you are, would you like to subscribe to X, Y, and Z? And then they activate that. So that's where the second kind of opt-in comes in.
Yep.
Yeah, the GDPR, it's format neutral. So if you're keeping any of the information about them, then you're doing something with their information, their personal information. So,
okay.
Yeah.
Great. Really good question from Rebecca. So it's around user profiling, and where does the chain of responsibility in user profiling lie? For example, on the Google network, I mean, is it Google, the ad agency, or the advertiser? Where does that sort of chain of responsibility and accountability lie from your point of view?
I've got a view on this, but Gail might be more up to date.
You go.
Oh, well, if you're the reason why I'm wondering if Gail's got a more up-to-date view of this is that there was some argy-bargy previously where Google was perhaps taking a different view to its customers as to whether or not it was responsible or its customers were responsible.
Yep.
I'm not sure where that's wound up at the moment, but if you're making decisions about how the data is used, or you're actually doing the processing, you're on the hook to some degree.
Yeah.
And you might both be responsible. That's the thing.
Okay.
Yeah, that's my understanding, is that the point of responsibility lies with where the processing happens and the decisioning happens. There is said to be a due kind of responsibility that you are obviously checking that you are compliant to the way that Google are doing it, and that you are aware of whatever Google or Facebook or any of the others clauses are, and by working in that way, you're kind of signing yourself up to being liable in some ways for the way that they will behave with that data. So I know that Google have updated a lot of their practices from where data is stored to the way that they will ensure that there is European compliance. It's just making sure that your terms and your behavior is aligning with that.
Yeah, there's so many different players and parties across the chain of responsibility, but I think what I'm hearing from your comments is that's not enough to sort of vindicate your own sort of responsibility there. So, a question that I've also gotten, and Ebony's asked as well, can people actually opt out of being targeted by your Facebook pixel, or can't they? Like, is that possible?
I'm not sure, actually. We'll have to get back to you on that.
Sure.
You can ask Facebook, but I'm not 100% sure. Legally, I imagine there must be a kind of responsibility of Facebook, but I'm not sure how it transpires back to
technically,
the
I don't know
purchase.
how.
Yep. No, we can we can take that question offline, and Ebony, happy to sort of answer that beyond this forum. Good question here from Amber around when people visit a website for the first time, like what sort of pop-ups should that particular business be serving upon them? Or I guess by implication, what should it not be serving upon them?
Gail, did you have an example from one of your
Um,
earlier?
so I haven't got an exact example if it's about cookie opt-ins, which I'm guessing if it's about visiting the Facebook, there is standardized copy that is GDPR compliant that people use. And again, like I was saying, I think we're going to get an onslaught of the first time people go to websites accepting, the pop-ups coming up with I accept.
Yes.
At the moment, that is the best practice way of doing it because it is visible, it's very transparent, and there is a clear consent. It is very action and orientated. And so I imagine we will just get kind of further coverage of all of those. But we can share some example best practice copy for that.
Okay. No, that's absolutely fine. So another slightly trickier question. I'm gonna put you both on the spot here. This is from Nick. So in regards to, and this is something that's pretty practical and relevant to the industry around what they do. So with regards to, let's say, event follow-up emails, can we email an attending participant to an event that we've organised with an opt-in option, even if that data was owned by an external organisation, such as a distribution partner who recruited for that particular event?
Short answer, and I'm not sure if I've grasped the full situation, would be I can't quite see how the GDPR would prevent you if you were marketing to them and you've got a connection with them, but then that doesn't necessarily tie in with the if someone else owns the data, that's almost a separate issue.
Well, I think it goes down to the language in that opt-in option. So if that opt-in option was that you were consenting to your data being given to an external organisation associated to the event, then yes, you could. However, if the opt-in was only opting you into communications to the event organiser, you couldn't.
Yep. No, and that's perfectly fair enough. So I think a question which we were talking about offline before this, this forum actually even started, and this is really important one from Chris around, does GDPR laws, or do GDPR laws and rights apply to EU citizens living abroad in Australia and other regions?
I think that whilst the GDPR does say that it's about processing the personal data of people who are in the EU,
yes,
it might be practically difficult to distinguish you're doing that when they're on the basis that they happen to be in Venezuela at the time or something like that.
Yes.
Or in Australia, for example. So I think practically it's unlikely, like technically you might reach one conclusion, but practically it mightn't be the best way to sort of avoid the application of the GDPR.
Okay. So. Yep. No, I think that's that's pretty sensible, and that's sort of something that I would sort of say as well. A question here from Dean. So if somebody downloads, let's say, an app from the App Store and then authenticates it with a service such as Strava, which then provides them with consumer details, does this imply consent, or is explicit consent still required? That's a slightly tricky one.
Yeah, I'm not 100% sure. I think you'd have to look at the individual.
Yeah.
And I think this comes back again into that sort of that chain of responsibility conversation around, where that relationship sits between yourself and the person that you are conducting that marketing activity through to. So, yeah. Any takers, or should we take that offline for that particular question? The one we just had around the app download.
I probably need to know more about how it worked.
No, absolutely fine. Question from Luke around, what are some of the things that a business should think about when selecting software or online tools in order to maintain a level of compliance?
I think it is about that level of compliance in. And again, to James's point earlier, where he was saying businesses have seen uptake when they put that their products are GDPR compliant.
Yes.
Again, businesses are talking about that. So I'm sure for the tools and the software that you're looking at, it will be a feature and a sales kind of benefit in the way that they approach it. So I think from a future-facing point of view, looking for ones that definitely have that built in is going to be the most sensible option.
Great. We'll go through a couple more questions which I think are important. So this is a good one from Fiona in terms of going back, into sort of archives and records. How far do we need to have evidence of opt-ins for databases? Like, is there any limitation around GDPR in terms of time periods? Do we have a...
So my understanding is there is no time period, so it doesn't say 5, 10 years. It is
right.
That's why time stamping has become time and date stamping has become very important in what is being done. From a marketing perspective, there is just a recency kind of challenge that ultimately you want to make sure your data is the most recent data you have, just from an efficiency and an engagement point of view. And that is why we have seen that GDPR has caused a shrinking in a number of databases, but more active and higher engaged databases. So it's a good data hygiene exercise, if nothing else.
Okay, all right. Ask a couple more questions around this. So one good question that we've got from Mark. So I think this is really important just in terms of next steps around where can a business get advice on all that is involved. Mark said that he's recently contacted 2 large law firms for advice, but was told that they are not familiar with the GDPR and that they would have to charge for research time. So I think this is probably a question that would be, in the minds of a lot of our participants today around what is the quickest and most accurate way to get, I guess, information and advice on what's involved without spending extraordinary amounts of money on law firms.
Well, look, just out of sympathy to the questioner there, we've all had to charge for large amounts of research time this year for GDPR. But I think it really depends on the scale of your business or the scale of what you're doing. There is actually quite a lot of useful information out there, both in terms of kind of software products you can buy if you're collecting information that way. Gail was giving some good examples before, but you probably, depending on the scale of your investment, you probably will need a lawyer at some point. But at the same time, if you've tried 2 large law firms, don't stop there. There will be specialists out there who know about this, especially with the private sector, small to medium business client focus.
I think if you're looking for less legal advice and just to understand it more, the ICO in the UK, who are obviously the body behind it, gives some really good, simple, kind of shorthand ways of understanding it. And so I'd recommend going to their website. They have some great guides.
And just building on, thank you for both of those examples. Just building on that, the Office of the Australian Information Commissioner is a really good resource for information as well. I mean, obviously, that information will stop short of providing advice specific to your business or your situation. But, if you want to look at a comparison around what the Australian legal framework looks like and then what the GDPR is, that's a really good place to get sort of going on that. Good question here from Brendan around, does the GDPR affect government departments or agencies within Australia?
Potentially, yes, but it really depends on what their activities are.
Right.
Because the GDPR is about what you do, not who you are.
Yes.
It's possible that who you are will make a difference, but one thing we have to underline here is that GDPR is really new, and whilst it's modelled on previous EU laws, some of the provisions that could be relevant to that question haven't been interpreted yet, basically.
Yes.
But for instance, if you're a government entity that has a part of its task is a commercial enterprise,
right,
then it's quite likely you're going to be treated the same way as any other business. So.
Okay. Perfect.
So there's just a question that's come up about the website, the UK website. So the ICO website, who are the independent authority in public interest against data, is ico.org.uk.
Perfect. That question's for Dean. Thank you, Dean, for asking that, and hopefully that information has been helpful. So, look, one final question that we'll sort of finish off with from Jack. So he's given us an example of obviously a website that he's recently visited around Ticketek. So he said, Ticketek have a pop-up on their sign-in screen that says, if you are visiting us from the EU, you may have additional rights beyond our privacy policy. By continuing to use our website, you provide your consent to the terms of our privacy policy, a copy of which can be found here. So I think this is a good question from Jack in terms of doing something along those lines. Does this offer protection from the EU GDPR?
I feel if I answer that, I might be giving legal advice, which I'm not meant to be doing.
No. Well, I guess I might rephrase that. So look, can...
The way I read that is that it's kind of they're opting out of being liable.
Okay.
So I read that as, so it is your choice now whether you are happy that we won't be complying to things. So that isn't advice or saying it's the right thing to do, but I think that's, if I was a user, I kind of find it that's what you're kind of telling me, is that actually I'm going to have to abide by your privacy rules rather than what I might be used to.
Thanks for
that.
No,
thank you. No, we don't want to. No, we don't want to be obviously, providing legal advice on that information. So, look, I think that's, I think that's pretty much a wrap on some really great questions. So I think the fact that James and both Gail have provided a really strong level of sort of information, both from a legal, marketing and examples point of view, and then some really pertinent questions from all of our participants today around what are the different types of conducts, what are the pitfalls, what should they watch out for, and where they can obtain more information. Look, I guess, and I think just a final sort of answer to a question from Reagan was around, can these webinar slides be downloaded? Yes, we will absolutely make sure. So that this webinar will actually be available on our YouTube channel, as I mentioned earlier. So it will be definitely available for you to review again and then share amongst your community to obtain more information. Yeah, and we'll also send the link to the participants as well. So look, a key purpose in us doing this today, in conjunction with Visit Victoria, was to raise awareness and create some education around what is a really important issue. So, and I think from here, the fact that participants have now, I guess, a basic overview understanding of, hey, these rules do actually exist, they might apply to my business, and then obviously the independent risk assessment that each business would need to actually then undertake, and then make sure that they manage their risks is upon them. But we've wanted to really make sure that we've provided a good overview of the information around what these rules are and how important they are. So, look, first of all, I just really would like to once again express our dearest thanks to both James and Gail for giving up their valuable time today and presenting on this very important topic and presenting different facets and different aspects of what the framework of these rules look like. So we're very grateful for both of your time and thank you very much for coming along today.
Thank you for having us.
Thank you.
Excellent, thank you. So look, just a very quick information on our next VTIC webinar. Will be held on Wednesday, the 17th of October, same time, 10:30 a.m. And the topic will be what can we find out by tracking tourists, which is a nice segue into what we've talked about today. And that will be facilitated with Martin Anderson from Tourism Research Technology presenting Gulliver. And just finally, a little reminder, we've got some very exciting and important events coming up as part of VTIC. We've got our VTIC mixer on the 3rd of October at the Wallace and Ed at the Windsor Hotel, followed by our sort of showpiece event for the year, which is the RACV Victorian Tourism Awards Gala ceremony. So really encourage you to get on board and get your tickets for what is always a spectacular night celebrating our industry. And then ending off the year in terms of official proceedings will be the VTIC annual general meeting on the 28th of November, where we'll reflect on the year that's passed and then kick off 2019. So once again, thank you to everybody for participating. I hope it's been useful to you all. And like I said, the webinar will be available on YouTube for your reference. But if there are any other questions around what information was provided today, my name's Rohish, Policy Manager at VTIC. Please don't hesitate to contact me. Thank you.